Thank you, sir.
No, we get paid by the hour.
Okay, thank you, Mr. Chair and members of the commission for your patience. A roll call, Commissioner Helfrey,
Here.
Commissioner Ward,
Here.
Commissioner Broyles,
Here.
Commissioner Clayton,
Here.
Commissioner Depp,
Here.
Commissioner Jackson, Commissioner Beatty, Chair Cohn,
Here.
Member Bros,
Here.
Mayor Boland.
Here.
Thank you.
Tonight, we have one letter of recommendation and 5 informational reports and 2 new correspondence on the agenda. I think the next item do we have a motion to approve the minutes from the Monday, February the 7th meeting?
I'll make a motion.
Okay, I second.
A second? I'm sorry, I did not hear who the second was. That Ms.
I would,
Mr. Helfrey?
yeah.
Okay,
I think Mrs. Helfrey made the motion and I seconded.
all right, thank you. The clarification. Okay. Minutes. Director Vunich, do you have any opening remarks this evening?
Mr. Chair, could we have a voice vote on the motion to approve the minutes?
Excuse me. Please, all in favor of the approval of the minutes, please say aye.
Aye.
Any opposed? Any abstention?
I abstain.
Thank you. Director
Thank you,
Vunich.
Mr. Chair. Mr. Chair, I do not have any opening remarks tonight for the department, but thank you.
Okay. Well, it's time for the public comment session. All public comments on the agenda items are accepted here. Okay. Yes, we have someone ready to make a public comment.
Mr. Chair,
Yes,
I may. If anyone would like to speak during public participation, we would ask that you use the raise hand feature. If that's not available, please put something in chat and Ms. Ripito, Mr. Newberry, or I will promote you to panelists so you can speak. You have 5 minutes, up to 5 minutes to speak. The department will be timing the 5-minute period. And once we get to about a minute or so, I'll advise that you're at a minute, and please adhere to the 5-minute time frame. We would appreciate it. Thank you.
thank you, Director Vunich, for reminding me. Senior Planner Travis, do we have anybody raising their hand?
Yes, sir, Mr. Chair. Mr. Petruska will be the first individual that is promoted. And I'll add one other reminder. If the speakers could each state their name, address, and identify which agenda item they are speaking towards, the commission would appreciate it. Thank you.
Thank you.
Mr. Petruska.
Hello.
Hello.
Hello, can you hear me?
Yes, we can hear you.
Oh, perfect.
Okay.
Well, good evening, everyone. My name is Ron Petruska. I live at 1700-009 Fallstone Mill Court in the Stone Mill subdivision. I'd like to ask a couple questions as it relates to the Ashley Grove proposal.
Go ahead.
Okay. As I mentioned, I live at 17009 Fallstone Mill Court, Stone Mill. And my home is one of the 4 homes that are adjacent to the southern border of the proposed Ashley Grove subdivision. I've been requested by other Stone Mill residents to ask the following questions on their behalf. The first issue has to do with the potable water pressure issue. I read the referenced American Water letter from Derek Lynham to Joe Vunich concerning potable water service to the existing homeowners. Mr. Lynham stated that American Water will continue to maintain the same water pressure regardless of the additional homes. So my question is, will they increase the main water line pressure, or will they increase the main water line sizes that service Stone Mill? And also, what kind of before and after testing protocol will American Water perform in order to ensure that water pressure coming into Stone Mill will not be reduced due to the additional homes in Ashley Grove and Wesley Parks? The second question I have has to do with the lot sizes and the architectural requirements in the proposed Ashley Grove subdivision. And we'd like to direct this question primarily to you, Mayor Boland, with the utmost respect. The city of Wildwood required that the developer of Stone Mill and also Old Town Park to have 15,000 square foot lots, 100-foot minimum frontages, side entry garages, and hardy board siding. All of the 17 of these new build houses, which are adjacent to the proposed Ashley Grove, meet these requirements. Mr. Mayor, we also recall that you stated during the June 7th, 2021 Zoom meeting that new houses that would be constructed in the 5-acre lots that would be Ashley Grove would meet the same size, architectural, and value requirements of the existing subdivisions. So based on this revised proposal that we see, we feel that the developer is being given preferential treatment since the requirements that the city of Wildwood insisted on for Stone Mill and Old Town Park are not being adhered to. So our question is quite simply, why is this the case? That's pretty much it. I thank you for the opportunity to allow me to pose these questions, and I look forward to your responses concerning these two issues.
Director Vonage, if I may, regarding the question
Mr.
on
Chairman?
water. Yes,
If I may interject here briefly, the public comment section is really just for public comment.
okay,
Any answers or responses, maybe if appropriate, and if can be given, could be given when the matter comes up and just for discussion. But during the public comment section, it should be really limited to the comments from the public.
thank you for the reminder. My mistake. Who do we have up next, Mr. Travis Newberry?
Mr. Chair, I will promote the next person with their hand up.
I think that it's my turn to speak. Thank you very much, Mr. Chairman, commission members, and other attendees. My name is Brooke Dubman. I'm in Maryland Heights, except for that I have property at 151 Strecker Road. I'm speaking in opposition to the overlay district being applied to the properties. I know the property owners in this area have invested lots of time and money to understand the issues regarding their properties. There's been environmental study after environmental study have shown that the properties are clear. Those properties are now safe, and unrestricted use is what is best for the health and welfare of the community. The city needs to listen to the experts and listen to the will of the people. I am not alone in my opinion. Please make note of other comments, testimonies, and signatures of nearly 90% of the adjacent property owners, plus many others. We are telling you we do not support the inclusion of these properties in the SCOD. Thank you for your time and attention.
Thank you for your comments.
Mr. Chair, the next individual is Ms. Placeway.
Is what?
Ms. Placeway.
Okay. Please promote her to the panel.
Okay, can you hear me?
Yes.
Okay, perfect. I'm actually speaking for my
Thank you.
father.
Name and address, please.
His name is David Kruger. He lives at 157 Strecker Road. His
And your address, please, since you're
My
speaking.
Yeah,
Yeah,
sure.
just-
My address is 436 Summertop Lane in Fenton, Missouri.
Thank you.
We are speaking on behalf of my father's property. He is the owner of 157 Strecker. He is one of the properties that is listed under the SCOD overlay. We are also voicing our opposition to the overlay. We spoke at the June 21 public hearing, and we just want to reiterate our opposition to the overlay. The city has listed a set of criteria for these properties that must be met to be placed under this overlay. The first of those is, has the property been listed or delisted from any federal, state, or local registry relative to environmental contamination? My father, David Kruger's property, has never been listed or delisted under any registry. The second criteria is if the property is located downstream from any site listed or delisted from a registry. Again, Mr. Kruger's property is far from any stream and is certainly not downstream from Lewis Spring, which I believe is the stream that everyone's concerned about. In fact, his property is quite the opposite. He sits on top of a hill far from that stream. The third criteria that the city has listed is that Mr. Kruger's property is not identified on a current or past phase 1 environmental assessment. His property also is not located on any portion of a main channel or floodway or watershed. Fifth, his property does not have more than 50% of the land area on an unaltered slope. As you can see, Mr. Kruger's property does not meet any of the criteria in which the city has listed for the SCOD overlay. To place him under this overlay would not only be unfair, but unjust. I also spoke to Mr. Vunich a few weeks ago. I asked him why my father's property was even listed. He said it was because he was in close proximity to formerly contaminated properties. So the thought crossed my mind, if my neighbor gets arrested and goes to jail because he commits a crime, does that mean I have to go to jail because I'm in close proximity? That is essentially the same punishment that you would be doing to my father. I've also been in contact with Linda Price with the EPA. And also, and I apologize, I will probably mispronounce his name, is Micah Lefkaru. He's with the Missouri Department of Natural Resources Superfund program. Both agencies, the EPA and Department of Natural Resources, have deemed not only my father's property safe, but all of the properties listed under the SCOD overlay as being contaminant-free and safe. Both of the agencies do not have any concerns with my father's property, nor have they ever had any concerns with his property. Mrs. Price also did indicate that the EPA is in the process of installing testing wells for runoff water. They stated they were hoping to have these in place within the next month. I feel that it would be a little premature for the city of Wildwood to proceed with an overlay without having all of the groundwater testing information. If nothing else, to table all of this until you have all of the data from the EPA, if they're in the process of putting these testing wells up.
1 minute left, Pam.
Okay. Also, Department of Natural Resources stated there are no current testing wells. The last time they tested anything was the Bliss property in 2016, and it was found to be contaminant free. DNR also verified there are no current testing wells on the property, the former Prim property, or any properties because they don't have any concerns, nor does the EPA. In closing, I would just like to remind everyone before they vote to think about not just the pieces of property, but these are everyone's individual lives, livelihood, and everything that they've worked for, that they put their hard work, invested money into their properties. It's not just a piece of land. It's someone's investment that you are going to be taking away. We ask that the city and the committee members take all relevant data into consideration prior to making their final decision. Thank you.
Thank you for your comment. Superintendent Newberry, who's next?
Yes, sir. Mr. Piantek is on his way in, Mr. Chair.
Sir, you're on mute.
Well, thank you. My name is Keith Piontek. I live at 4617 Vixen Circle. I'm a professional engineer in the state of Missouri with 35 years of experience in the investigation and cleanup of contaminated properties. And I'd like to speak on the agenda item 2D, the Special Condition Overlay District. I've reviewed the city's information report that was made available on Friday last week, and I do not find the evidence that imposing an overlay district on the Callahan site is, in the words of the city's report, quote, necessary to ensure the protection of the health, safety, and general welfare of the residents of the city, end quote. Instead, what I found in that information report is use of obsolete information, some outright errors, biased opinions, and the absence of what I consider to be highly relevant information. And I would like to explain. In the city's information report, the technical case for imposing the overlay district on the Callahan property is comprised of excerpts from a report that's called the White Paper. And as I will explain, this white paper is riddled with obsolete information, errors, and bias. The city's report states that the white paper is derived in part from a Mundell report dated November 2012. And that report was written before the cleanup and assessment of the Callahan site was completed. And so there's information in that Mundell report working its way into the white paper that's obsolete. There's also some outright errors in the white paper that's incorporated into the information report. For example, on page 8 of the city's report, item 3K reads, only one groundwater monitoring well was installed on site. And that's just not true. There's a January 2012 Missouri Department of Natural Resources report that documents the installation of 3 wells on the Callahan site and 3 more on the adjacent property. So that's an example of a outright erroneous statement. In addition to those errors in the white paper, it also contains a number of opinions presented as fact, which I think would be more accurately characterized as prejudicial misrepresentations of the underlying facts. And I'll deal with another example of that. On page 8 of the information report, items 1B and 2F, those are criticisms of the sampling methodology that was used at the Callahan site. These items state composite sampling, quote, is not suitable for future site development of residences on a lot division basis, end quote. Well, arguably, this comment would be valid if you're using a single composite sample to characterize a large area that could be subdivided into smaller individual home sites. But that's not the situation we're dealing with. I drilled into the April 2013 removal action report on the Callahan site for the details of the composite sampling they performed. And we're not dealing with an extensive area. We're dealing with an area of approximately 70 feet by 70 feet where that composite sampling was done. And there wasn't a single composite sample in that area. There were seven different composite samples collected in that small area. And the maximum length over which a composite sample was collected was a mere 45 feet. In light of these details, the criticism in the white paper of the composite
1
sample.
minute.
Okay, thank you. It appears to be nothing more than an attempt to muddy the water, making a big deal about next to nothing. The use of composite sampling as implemented on the Callahan site was valid. And I take exception to not only the information, the flawed information that was included in the city's report, but also what was omitted. In July of 2021, the city sent a letter to EPA with a list of concerns about the Callahan site. In August, the EPA responded with a letter. They addressed each of the city's questions, and they concluded with the reiteration that the Callahan property has been cleaned up to a standard suitable for unlimited use and unrestricted exposure. I don't know why that report wasn't included in the information report. It seems highly relevant.
I'm up.
Thank you for your comments. Senior Planner Newberry, we have any others?
Yes, sir, Mr. Chair. The next speaker is Mr. Moan.
You're on mute.
Can you hear me now?
Yes.
Okay, my name is Emily Moan. My address is 1026 Timberfield Drive in Ballin. I am speaking on behalf of David Kruger, my grandfather. His address is 157 Strecker Road. My grandfather has been living at 157 Strecker Road for over 50 years. He and my grandmother worked hard to make lots of renovations to this house and property in order to better themselves and the city of Wildwood. He has been a loyal resident for decades. We lost my grandmother in 2020, and ever since then, this pointless overlay has only been adding to his stress. As his granddaughter, I am fighting to help my grandfather keep everything he has built from the unfair government that is attempting to take his life's work. We have made numerous attempts to get information and help in understanding this overlay, yet have not been given any resources from the city of Wildwood. It also seems that the council men and women were not given all of the resources to be educated properly on this overlay. So I ask you two questions. One, are you sure the council members understand the definition of overlay? And two, are you sure the council members understand the effects this would have on your innocent residents? I studied environmental science for many years. The Environmental Protection Agency considers levels of dioxin up to 50 parts per trillion safe. This is a natural element, meaning every piece of land has some level of dioxin. My family and I have never had any effects from dioxin. Dioxin is also a chemical that breaks down the longer it sits. Essentially, the overlay should be shrinking, not growing. If the dioxin levels were dangerous, there would be no wildlife. So I ask you two questions. One, if the EPA has clearly deemed these properties safe and not impacted by dioxin, why are they now in an overlay? And two, how is it that we grow a huge garden every year and constantly see wildlife? Years ago, the same actions happened to many innocent residents in the area that is now called Times Beach. These properties were unfairly taken from these homeowners only to become a public park. So I ask you two questions. One, is Wildwood planning to do the same? And two, is this for your own personal gain? From my research, the EPA tested the areas of concern after the dioxin was introduced. But from the records and speaking to the EPA, 157 Strecker Road has never been tested because it was never in the area of concern. My grandfather received a letter from the EPA stating, quote, based on this information, there is no reason to believe that properties located immediately to the west of the Bliss-Ellisville Superfund site are affected or impacted by the contaminants of concern identified at the Bliss-Ellisville site. Because of this, the EPA supports the intended future use of the property as a residential subdivision. That letter was dated in 2018. 157 Strecker Road has been deemed safe for over 4 years. So I ask you, why are these properties suddenly contaminated? There is a creek that runs far behind my grandfather's property. It is at least a quarter of a mile behind his property, and in the 21 years I have spent there, I was never aware of this creek. The water is even flowing downstream and away from the house and surrounding yard, so this should not even be a concern. Environmental tests are considered public information. So I ask you 2 questions. 1, why were the EPA test results never given to the public? And 2, where are the test results from the private company that Wildwood hired which deemed these properties unsafe? I am also studying for my real estate agent license. Taking is a term defined in my textbook as taking a property for public use. This clause is found in the 5th Amendment of the United States Constitution, which reads, "Nor shall private property be taken for public use without just compensation." This is exactly what Wildwood is doing. You are taking my grandfather's property, along with many others, without any compensation, because you are making their property worth nothing to benefit yourselves and others. My textbook also defines inverse condemnation as an action brought by a property
1
owner
minute.
just compensation for land adjacent to land used for a public purpose when the property's use and value have been diminished. This means regardless of this overlay being placed, my grandfather's property value will diminish. So I ask you, where is my grandfather's compensation? With all that said, this overlay is completely unfair, and voting yes to this overlay will destroy everything my grandfather has worked for. This overlay is completely unjust and uncalled for. There is no evidence that points to 157 Strecker Road being in any danger from dioxin. I will never stop fighting regardless of the outcome here tonight. So I ask you 2 questions. 1, where is your proof? And 2, what is Wildwood hiding from their residents? Thank you.
Thank you.
Mr. Chair, the next speaker is Ms. Bruno.
Please bring her in. And Ms. Bruno, you're on mute.
Okay, can you hear me?
Yes.
Okay, my address is 16551 Victoria Crossing Drive in Wildwood. My father's address is 1627 and 1650 Idle Rock Farm. First, I'd like to echo the comments that have already been said and apologize if I repeat. We have owned this property since 1978. It makes up 14 acres. That are 2 of the parcels, 1627 and 1650. We border Callahan to the south. My father's 85 years old. He's with me today. Me and my 3 other brothers and sisters do want to thank the commission for their service. We realize you are volunteers and that this material is not easily digested. It's called Idle Rock Farm for a reason. It's because it's on a rock and our house is on the top of a hill. If there's any kind of a stream or water it's way down at the very bottom of the property. We have had, the history of the property is we've had horses and cattle that have been digesting and frolicking in this dry creek bed and surely drinking it if there was some water in there in the spring. And they've not been sick. We've played all over this property when we were kids. All 4 of us were healthy. We're all over the age of 50. And there have been numerous soil assessments done on this property over the last 45 years. I'm guessing at least 4 or 5, maybe 6. They were all done under the City of Wildwood's watch. MSD did testing and Missouri American Water did testing because they both dug very deep lines down in the lower parts of the property in the late 90s and early 2000s. There was another assessment done in 2008. These were all negative. There were other assessments done that Wildwood has in its possession, but the time that I have here, it doesn't allow me to go through them all. They were all negative, I assure you, and Joe knows this. More importantly, though, my question is, does the Planning and Zoning Commission know this? Have you all done your due diligence and looked at the history of the test of our property? It doesn't belong in the SCODE. The next topic I'd like to discuss is how much money this is going to cost for me and my neighbors if this were to happen to them as well. Here's an example. If I want to build a storage shed or my dream home, it's going to cost me first, number one, $5,000 to get environmental report, which code says is only good for 6 months. So if the commission delays me for 6 months, I have to pay again for another one. But Wildwood is relying on data that's 7, 8, 10 years old for SCODE determination. Additionally, SCODE states that Wildwood will hire an expert to evaluate my newly created 5K expert report. I have to pay for this expert however much they cost. Meanwhile, the Callahan property has already been assessed just recently by Mr. Marquardt and his family, who paid for that to be done last year and got the all clear. This is an example of shifting the burden off of the government and onto the local homeowners and the neighborhood. In addition, as Carrie Placeway said, the EPA has agreed to put more monitoring wells in the area. Could we please let them do their job? And I have one more thing to say. Wildwood already has plenty of regulations embedded in its construction review process. SCODE was designed for Superfund sites. I'm not a Superfund site, and please don't treat me as such. Please don't devalue my property and all those that surround it. And please don't put 14 pages of restrictions on us. Thank you.
Thank you for your comments.
Mr. Chair, the next speaker is Mr. Kurt Marquardt.
Hello, my name is Kurt Marquardt of 328 Southeast Cantor in Lee Summit, Missouri. I'm here on behalf of Scott and Tiffany Marquardt, owners of 162 and 210 Strecker Road. I have previously commented to this board last June. I'm a former Missouri State Highway Patrolman and currently am a lawyer in private practice. As I reviewed the information report prepared by someone for this meeting, I was drawn to the summary of facts and recommendations. In the paragraph before the summary and repeated multiple times in the summary, the unknown writer states that such action is to the benefit of the health, safety, and general welfare of the residents of the city, and that the action is reasonable, appropriate, and necessary. If the instigators of this action's concern is for the health, safety, and general welfare of the residents of Wildwood, why does the city and its employees engage in this types of behavior that demonstrates otherwise? Why does the city ignore the findings of the EPA, which shows that the residents would be safe on these properties? Why does the city refuse requests for information from residents? Why does the city restrict which city employees residents can contact? Why does the city initially inhibit a resident's ability to obtain and review the white paper, forcing the resident to file a sunshine records request before they would provide it? Why does the city refuse to allow the firm that prepared the white paper to speak to resident experts who discovered significant errors and weaknesses in the white paper? The errors and weaknesses could thus be corrected, ensuring accurate information would be used in formulating policies that benefit the health, safety, and general welfare of the residents. Why does the city want to build a sidewalk on these properties if it would actually expose residents to harm? Why does the city refuse to meet with residents to discuss their health, safety, and general welfare concerns? Why was a city resident confronted in the parking lot of City Hall and threatened and intimidated, being told that his family would never get what they wanted? This is the opposite of taking actions that are for the health, safety, and general welfare of the residents. Actually, I might think that this is even a crime. Why does the city limit the time and information presented at hearings and meetings when getting the whole accurate story would be in the actual interest of the health, safety, and general welfare of the residents? This kind of conduct makes me wonder what goes on in the other city businesses. It is either willfully ignorant or intentionally indifferent to present it with the opportunity to get the whole and accurate information and then not get that information. Don't be willfully ignorant or intentionally indifferent. Demand, get, and review all the facts before making the decision. Your decision will be for the health, safety, and general welfare of the residents. Your duty is to guarantee to make your decisions on all facts available. not just ones handed to you and couched in the terms that those restrictions are reasonable, appropriate, and necessary. Looking at the city actions in this matter, it's obvious they have not demonstrated the reasonableness, appropriateness, or actual necessity of the inclusion of 162 or 210 Strecker Road in this SCOD. And I ask that you vote to exclude these properties. Thank you for your time.
Thank you, sir. Senior Planner Newberry, we have another speaker.
Yes, sir. The next individual is listed as Christine on Zoom.
Thank you.
Hi, this is Christine Loveland, and I'm speaking regarding the PZ 28-21 Ashley Grove Cypress Real Estate.
Can we have your address, please?
It is 2604 Center Avenue here in Wildwood. I just want to say that we are against the smaller homes being built by us. We moved to Wildwood because we experienced this exact thing in Fenton, where we built a 3,000 square foot home and they built 1,500 square foot homes right next to us. So the value went way, way down, and we had to rent our house out for 3 years in order to get even sell our house for what it was even worth, or even what we bought it for. So I just wanted to let you know my thoughts on that. Thank you.
Thank you for your comments.
Mr. Chair, the next individual is Kurt Fanistock.
Please bring them in.
Hello, can you hear me?
Yes. Yeah.
Great. My name is Kurt Fonstock. I'm an environmental professional residing in Columbia, Illinois. I'd like to speak to the application of the SCOD to the properties at 162 and 210 Strecker Road. About 8 months ago, I did a pretty in-depth technical records review of the activities that have taken place in that area on those two properties. The review indicated that there were no remaining environmental concerns existing at the properties, and that the properties required no additional investigation, no remedial actions, no institutional controls, and no continued monitoring in order for them to be suitable for unlimited use and unrestricted exposure. Now that review covered documentation of almost 40 years of sampling, analysis, remedial actions, risk assessment in that area. The property currently presents no evidence of environmental threats, regardless of its intended future use. The same conclusion was reached by Tetra Tech, the consultant working for the US EPA, the Missouri Department of Natural Resources, and the United States Environmental Protection Agency. The former Callahan property, separate from the other two properties included in the Ellisville site, has been delisted from the national priorities list because it's been thoroughly investigated and remediated. While this may not be the case for the other properties, no deed restrictions have been placed on the property, and there is no technical support to prohibit its unrestricted use by a zoning ordinance. And that's all I've got to say. Thank you for your time.
Thank you for your comments.
Mr. Chair, I'll be letting in the next speakers.
So I say again.
I just wanted to let you know I'm letting in another speaker.
Thank you.
Hi, Elaine Marquardt, 834 Holly Ridge Drive, Baldwin. I'm speaking regarding the SCOD. I would like to express some points that really make me question and doubt the legitimacy of the SCOD process. I support the position that these properties should not be included in the SCOD. My husband and son spent hours and hours and hours sorting through years of information regarding 162 and 210. They wrote down pertinent, accurate, and concise information and provided that to the city. They asked for that information to be given to the commission, but it was not. Why was it not shared with all of you? Is someone trying to sway your vote by only feeding you the information they want you to have to secure the vote they want you to make? The information they prepared and hope to share with you shows that the properties are safe and do not belong in the SCOD. Another question I have is, why is there continued emphasis placed on the easily discredited and inaccurate white paper? It is very suspicious when it is unsigned and the authors aren't even listed. Who does that? Someone that doesn't want to be questioned because they can't defend their position? I made my talk very short so someone else may be able to use my extra time. Thank you for your time and consideration.
Thank you for your comments.
Travis, is it okay to proceed? Is it my turn, Travis?
Mr. Chair, another speaker is on the same Zoom call.
Okay, name and address, please.
My name is Dwayne Marquardt, 834 Holly Ridge Drive, Baldwin, Missouri. I'm speaking regarding the SCOD properties 162 and 210 Strecker Road. Mr. Chairman, commission members, and everyone else attending this meeting. First, quickly an introduction. I've been fortunate in my years. I have multiple degrees, including several bachelor's, graduate, postgraduate, and professional degrees. I'm a licensed chiropractic physician, a functional medicine physician, and a practicing radiologist. I've been in professional practice nearly 40 years. I'm retired from teaching 20 years at the graduate, professional, and postgraduate level. I'm a father of 4, have 10 grandchildren, and it's from this experience I want to make these remarks. I know the science, but more importantly, as a physician, I pay attention to the details and I listen closely to each situation. As a teacher, I strive to understand and then communicate the relevant points. As an old-fashioned teacher, I respectfully ask you to remember these 4 words. Listen to the people. After being involved in these dealings with the city of Wildwood and the SCOD, I want to say that there is something drastically flawed driving this process. This is not only my opinion, but the feelings of many. Let me explain. Listen to the people. They are telling you in every possible way there is the appearance and evidence of deceit, deception, withholding information, intimidation, deliberate distractions, and many others. Listen to the people, the water specialists, the epidemiologists, the teachers, the scientists, the residents, the neighbors, the families, and others that are all willing to testify. They're willing to write in. They're willing to comment about the inconsistencies and the wrong interpretations related to the SCOD. They are all telling you that there's something drastically flawed driving this process. Listen to the experts. The experts are telling you about the inconsistencies. They're telling you the white paper is flawed. They're telling you the important data has been withheld from you. They've explained how this is not a solution to the condescending hype over protecting our safety. They are telling you the science does not support the SCOD in these cases. They have proven these properties do not belong in the SCOD. Listen to the staff. The City of Wildwood staff and employees are signaling that there is something drastically flawed. I am not blaming the personnel. I'm only reporting the actions. There are serious delays in communication. Frequently, phone calls and emails get no response. Important information is not forwarded. Communication is stifled and must go through unusual channels. Communication There are many other obvious irregularities. Council members have been provided inaccurate information. The mayor makes intimidating and threatening remarks to the residents. Condescending and patronizing remarks are made regarding safety, liability, and the good of the city. The attorney does the training and tells the commission, you don't need to document why you voted, just vote. It's his job to justify it later. Commission members are given such limited data that they resort to, well, if we err, we at least ought to err on the side of safety. There is something drastically flawed driving this process. Why would they even risk letting you make an error? Listen to the people. They're telling you their frustration about the appearance of deception. Transparency is limited. Zoom meetings instead of face-to-face. Information packets that contain over 30 pages of information not related to the topic at hand. Only 3 minutes to talk about 5 properties. Well, I changed that. It's 5. Thank you. 5 minutes to talk about properties. Position statements and recommendations published at quitting time on Friday. Remember, whenever there is deception, there will always be a fabricated justification. Listen to the people. They are telling you that there is proof these properties do not belong in the SCOD.
1 minute.
50% of the residents of the neighboring properties and many other people have made their recommendation by their signature. You have witnessed many comments, testimonies, and messages that tell you they do not want the SCOD applied to these remaining properties. Mr. Cohn, Mr. Clayton, Ms. Ward, Ms. Helfrey, Ms. Broyles, please listen to the people and do not let these properties become a casualty of this drastically flawed process. There is proof that these properties do not belong in the SCOD. Thank you very much for your time and attention.
Thank you for your comments.
Mr. Chair, the next speaker will be Scott Marquardt.
Okay.
Mr. Chairman.
Yes, Mayor Pullen.
If I may, it seems to me, and this is your call, it seems to me we're getting a lot of repetitive comments on the same property. I think it would help the commission if there's anything new. Certainly they're entitled, anyone can speak, I guess, repetitively, although that's your decision as chair, presumably. But I think it would help if there's anything new that would be most beneficial at this point. Thank you.
Thank you for your suggestion. I agree. Does the speaker have some new information to provide to the commission?
Yes, thank you. Can you hear me?
Yes, name and address, please.
I will be speaking first, and then my husband, Scott, will be speaking separately. My name is Tiffany Marquardt, and I am the owner of 162 and 210 Strecker Road in Ward 4. I'm looking forward to moving into my new home later this summer, and I am speaking in opposition of incorporation of certain properties in the SCOD. I'm speaking tonight, urging you to consider the facts before you this evening rather than the fears of what if in regards to including properties in the SCOD. While I am the owner of 2 of the properties under consideration tonight, I also hold a master's degree in public health, epidemiology, and biostatistics with past positions at the CDC, Pennsylvania Department of Health, St. Louis County Department of Health, and a private university as an adjunct faculty member, all in addition in my role as a mother, business owner, and homeowner in Wildwood. In my years of education, training, and practice in public health, what happens very often is that the public makes an outcry that something must be done for whatever situation. Someone gets sick after eating at a restaurant, and we must shut the place down without any consideration of what actually made someone sick. Well, in my expertise, we have to look at the facts. What is really at stake here? What do the facts lead us to do? In 2010, I was the lead epidemiologist at St. Louis County during an outbreak of cryptosporidium affecting local pools. Hundreds of people in this county had diarrheal illness from this parasite, some even hospitalized due to complications. So what did I do? I consulted with the state as well as the experts at CDC and waterborne illness for an action plan. In the meantime, county citizens were demanding action be taken for the situation, and managers at the health department felt something needed to be done immediately. The local health department decided to hyperchlorinate 1,100 public pools to rid them of this parasite after being advised by CDC to not do it and hearing that chlorination did not kill this parasite. In fact, they hyperchlorinated those same pools twice that summer. Both times they failed to kill the parasite and stop the outbreak because, again, hyperchlorination is not effective as stated by the waterborne disease experts. So why did the county choose to waste thousands of dollars and time, all when the experts said this was not an effective action plan? They did this because it looked good and it pleased the public. Something was being done. Does this mean it's the right thing to do? Absolutely not. For those interested, the outbreak ended exactly when we told them it would end, 3 weeks after Labor Day when the pools were closed. So do you think you just need to do something? I understand and want to make sure everyone is safe just as you do, but the scientific facts do not support the SCOD. Ellisville was falling into the same trap this year. Ellisville's council heard Wildwood was doing something, so they asked their planning department to write legislation as well. This legislation was included as part of the information report the department prepared in advance of tonight's meeting. However, what you were not told is that the Ellisville Planning Commission did not support the legislation. In fact, most of the administration and council in Ellisville does not support the legislation, stating it is overreaching and unnecessary. I am also concerned in Wildwood's case that you as a commission do not even have all the facts to consider. Many documents written by experts in the field, both at EPA and with private agencies, are not being shared for your consideration. My husband and father-in-law have spent hundreds of hours over the last year making all of these documents available to you on a website and emailing them to Mr. Cross to distribute to you. As an epidemiologist, the first thing we learn and do is consider all of the evidence before making decisions, as should you. I urge you to consider the facts before you this evening rather than the fears of what if. I am confident the facts as presented by the experts this evening will lead you to the conclusion that these properties should be excluded from the SCOD, or at minimum, you delay voting so you have time to review all of the evidence and make an educated decision rather than being told what to do by the city of Wildwood. Thank you.
Thank you.
Next.
Mr. Cohn, would you like me to proceed?
Yes, please give your name and address, please.
Certainly. My name is Scott Marquardt, and I am the owner of the property at 162 and 210 Strecker Road in Ward 4. And I too am looking forward to moving into our new home later this summer. I want to say good evening to you, Mr. Mayor, Mr. Chairman, and to the commission members. I am here tonight in opposition of the application of the SCOD on our property at 162 Strecker Road and 210 Strecker Road. I want to make sure that you have the most accurate data possible, and therefore you can make the best decision for our community. Now, only a portion of the property at 210 Strecker was ever a part of the EPA Superfund site. None of the other properties that are on the agenda for this evening were ever a part of the Superfund. Also, the property at 210 Strecker Road has been tested over 50 times for dioxin. Never has dioxin been tested there. So I want to repeat, the property at 210 Strecker Road has been tested over 50 times for dioxin, and it has never been detected there. So this evening, as an expert in the matter, Mr. Piontek testified that composite sampling was appropriate as it was used to assess the site conditions. The concerns mentioned in the city's white paper were appropriately addressed by both Mr. Fonstock and Mr. Piontek. They're both experts in this field. I am not an expert in the field. During the meetings on January 18th and February 7th, Commissioner Helfrey, Commissioner Broyles, and Chairman Beatty, you all asked great questions. Some of those questions were answered by the department. Others were not answered. Please do not hesitate to ask questions of the department this evening and make sure that you receive sufficient answers to support, sufficient answers with supported documentation from the experts in the field before you make any voting. So I think the white paper was an excellent attempt to summarize thousands of pages of data, but it's unsigned. And furthermore, the review of the document has found significant flaws that must be resolved. So The people of Wildwood do not support inclusion of the property at 210 Strecker Road in the SCOD. The data does not support inclusion of the property at 210 Strecker Road in the SCOD. The decision tables do not support inclusion of the property at 210 Strecker Road. The experts do not support inclusion of the property at 210 Strecker Road. Mayor Boland, I know you're not a fan of putting restrictions on landowners, especially not without clear justification. Please do not let the department do that tonight without abundant proof. So through this process, the department is putting a burden on all of the landowners to prove their innocence. We've already proven ample evidence that there is no further contamination at these sites. We've already performed many of the steps outlined in the SCOD, and all of the experts agree that no further testing is required. Therefore, there is no evidence to support the inclusion of 210 Strecker Road. According to the 3 separate studies that were performed in 2021, all contamination that ever existed on the site has been totally remediated. Given that there is no contamination on Strecker Road on the 210 site, there's no reason to support inclusion of any of the other properties.
1 minute.
I've done my part. My family's done our part. It's not fair for the department to keep saying it's not safe, but they're not sharing any evidence to support their opinion. You cannot, in good faith, be able to make a decision without accurate data available to you. Chairman Cohn, I ask you, or I urge you, to ask for a motion to exclude these properties from the SCOD this evening. If you, the commission, are not able to vote to exclude the properties, then you need to table the vote until all the information is made available to you to support your vote for exclusion. Thank you for your service to the city of Wildwood.
Thank you for your comments, sir.
You're welcome.
Mr. Chair, the next speaker is Mr. Dalton.
Please bring him in.
Good evening, Chairman, members of the committee, Mayor Boland. My name is John Dalton, and I'm a partner with the law firm of Armstrong Teasdale. My address is 7800 Forsyth Boulevard, St. Louis, Missouri 63105. I have the privilege of serving as legal counsel to Scott Marquardt regarding his property interests in 162 and 210 Strecker Road. I want to thank each and every one of you for your service to the city of Wildwood and its residents, and your consideration of all matters relating to the Special Circumstances Overlay District. To avoid being repetitive, I will shorten my remarks because you've heard extensively from other people interested in this matter. But burdening property owners' rights with new and additional legal requirements is a very significant matter, one that I know this commission takes seriously. A lot of information has been submitted to the city with respect to my client's property and the basis for his position that 162 Strecker Road and 210 Strecker Road not be included in the Special Circumstances Overlay District. Expert opinions, reports, and other materials have accompanied those submissions. Before any decision is made burdening these properties with the overlay district, I submit it's in the best interest of all parties, the city, property owners, and the city's residents, to have an open, honest, and full exchange of information so that the best decisions can be made and everyone involved can appreciate the process, the rationale, and any final decisions that this commission and ultimately the city council makes regarding the Special Circumstances Overlay District and its imposition on certain properties. This matter's been going on for years. To rush a final decision will leave people frustrated and worse when the same is not necessary. And with further exchanges with the city and its residents, you have the opportunity to generate insight and understanding throughout the impact zone and the community at large. Therefore, we would respectfully request a continuance on further action until such exchanges can meaningfully occur. It helps us all. It's what you want in serving your residents. You want people to understand what's going on. And I think you can take away from the comments tonight that they don't. And that's not good for anybody. The city may have a clear path in its decision, and it may have a good justification for it. But as your comments suggest tonight, people don't get it. So don't rush. It's our position that by taking the time, engaging the impact property owners and the citizens at large, you'll have a great opportunity to have buy-in to what's in the best interest of the city. I know Mayor Bolin well. He cares about his community, as do everybody on this call. And by delaying action on this, engaging the community, and a certain response may be we've done that, but I don't think that's clear from the comments tonight. Thank you for the time. Again, thank you for your service, and we appreciate the opportunity to appear before you.
Thank you for your comments.
Mr. Chair, at this time, there are no other hands raised in the Zoom call, and all of the individuals, take that back. Mr. Eisman has raised his hand.
Before he comes in, just remind everyone that unless you have something new to add, please limit your comments just to express your opinion. Thank you. Go ahead and bring him in.
Thank you.
Unmute. Hello, can you hear me?
Yes.
Okay, thanks. My name is Rick Eisenman. I live at 17004 Fallstone Mill Court, and I'm one of the trustees of Stone Mill Subdivision. Where I live, we're adjacent to the proposed Ashley Grove development. The Stone Mill subdivision, as well as others adjacent to the property, are certainly not opposed to this development. What we are opposed to is a number of homes proposed, which is 12 plus one existing home. We feel only 8 homes plus one existing home will allow the full 100-foot frontage, the 15,000 square foot lots, and the side entrance garages. All of these were required by the builder of Stone Mill subdivision and others surrounding this development. That's all I got to say. Thanks for your time.
Thank you for your comments. Mr. Newberry, anyone else?
Mr. Chair, give me a moment. Mr. Chair, at this time, I'll state again, there are no hands raised in the attendees of the Zoom call, and each of the individuals who have commented wishing to speak have been given the opportunity to speak.
So at this point, I guess we will close the public comment session and move on to the first item for consideration, which I believe is old business. Mr. Travis, I guess it's what, PC 30-21?
Yes, sir.
Could you please read that?
Thank you. PZ 30-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall, 16860 Main Street, Wildwood, Missouri 63040. A request for the consideration of certain changes to Chapter 415 of the Code of Ordinances of the City of Wildwood by enacting a new section 415.600 supplementary regulations for agricultural and aquacultural operations, which would thereby allow the restoration and authorization of any any use permitted by right on any site therein having said type of activity in association with it without affecting its non-conforming nature, all wards.
Mr. Vunich, your presentation, please.
Thank you, Mr. Chair. Mr. Chair and members of the Planning and Zoning Commission, for your consideration tonight, the Department of Planning has prepared the draft letter of recommendation that now reflects the Commission's action from the February 7th, 2022 meeting. That action was to deny the modification of the permitted uses in association with an existing aquaculture operation. Therefore, tonight, the letter of recommendation in draft form represents no change to the current regulations as set forth in the zoning ordinance. The draft letter of recommendation is in the appropriate form to forward to City Council. And if there are any questions after a motion and second, the department would be glad to try to answer them. Thank you.
Thank you. Is there a motion to comment? Have a discussion? Well, seeing none, do we go to a roll call vote on something, on your recommendation?
The recommendation that's contained in the letter reflects the unanimous denial of any changes by the commission from its last meeting. So a motion and second to accept the report as drafted would be appropriate, so as the commission's action would be forwarded to City Council. Thank you.
Commissioner Helfrey.
I vote to accept the recommendation.
Do we have a second? Commissioner Broyles. We have a first and a second. It would be time for a roll call vote.
Thank you, Mr. Chair. Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Helfrey,
Yes.
Chair Cohn,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Thank you.
Thank you. Director Vunich, would you please read PZ 9-20?
Yes, sir. Wrong paper, sorry. The first of the information reports tonight is PZ 9-20, New Singular Wireless, PCS LLC, doing business as AT&T Wireless, 1025 Lenox Park Boulevard, Northeast, 3rd floor, Atlanta, Georgia, 30319, care of Matt Schleter, Network Real Estate LLC, 5055 State Route N, St. Charles, Missouri, 63304. A request for a conditional use permit, CUP, within the NU non-urban district for a 12.3 acre tract of land, of which 2,869 square feet of the total area of this lot is to be utilized for a 195-foot tall monopole telecommunication purposes, along with associated equipment area, such being encumbered by a lease established for this purpose. The tract of land is generally located on the northwest side of Shepherd Road, west of its intersection with State Route 109. St. Louis County locator number 22V140282, street address 2001 Shepherd Road, St. Alban Road, Catholic Parish. Proposed use, a 195-foot telecommunications tower with related equipment area. The tower is proposed to be a monopole type with exterior antenna arrays. This particular property is located in Ward 1. Thank you.
Thank you. Before the presentation, did you want to make a comment, Mayor Boland?
Actually, I'm going to make a motion.
Before the presentation by Senior Planner Newberry?
No, he can go ahead and present. That's fine.
Thank you. Mr. Newberry.
Mr. Chair, if I may, I believe
Yes.
Ms. Helfrey has a request.
I didn't see. I'm sorry.
Thank you, Mr. Riddich. I just need to abstain from this one.
Say again, please.
I need to abstain from this information report. Thank you.
Understood. Do we want to proceed, Mr. Newberry?
Yes, sir, Mr. Chair. The department will be brief in its presentation. Mr. Chair, members of the Planning and Zoning Commission, the Department of Planning is prepared for your consideration tonight its information report with recommendation regarding the proposed telecommunication tower. This item was presented to the commission in detail at its February 7, 2022 meeting. At that time, the Planning and Zoning Commission requested a postponement and acted on such. Again, the department can go in more detail if the commission desires it. However, the department's presenting its information report with recommendation for support of the requested conditional use permit based on the analysis provided in its report and conditioned upon the list of conditions listed in attachment B that's attached to it. With that, Mr. Chair, the department's available for any questions or additional detail if the commission would like that.
Thank you, Mr. Newberry. Mayor Boland.
So thank you, Mr. Chairman, and thanks for that presentation, Travis. I would say that these decisions are very difficult for me, and I'm sure for all of us, relative to the things that we have to balance in terms of aesthetics and what we would like to do. But ultimately, we are bound by federal and state law as to, actually, I would use the word limited, by federal and state law as to what we can and cannot do here. And with that, I would make a motion to approve the department's recommendation subject to the granting of any variance that may be needed by our Board of Adjustment.
Is there a second?
I second that.
Thank you, Commissioner Ward. We have a motion and a second. Any discussion? I believe that would it be appropriate then for a roll call vote?
Yes, sir, Mr. Chair.
All right, let's proceed. This will be to approve the recommendations by the planning and by the director of planning.
Subject to approval by any variance by the Board of Adjustment.
Yes, thank you, sir.
Thank you, Mr. Chair. Commissioner Broyles.
Yes.
Commissioner Clayton.
Yes.
Commissioner Depler. I'm sorry, Ms. Depler, I didn't hear you.
Yes.
I apologize. Commissioner Helfrey.
Abstain.
Thank you. Commissioner Ward.
Yes.
Chair Cohn.
Yes.
Councilmember Brost.
Yes.
Mayor Boland.
Yes.
Thank you.
Mr. Newberry, you're next to read PZ 31-21, if you would, please.
Thank you, Mr. Chair. PZ 31-21 Wesley Park, care of Mike Whalen, Whalen Custom Homes, 338 South Kirkwood Road, Kirkwood, Missouri, 63122. They request for a change in zoning from the R1 1-acre residence district with a conditional use permit CUP to the R3 10,000 square foot residence district for a 1.39 acre parcel of ground that is designated the neighborhood edge district of the Town Center Regulating Plan and located on the east side of Center Avenue at its intersection with Bordeaux Walkway. Street address 2630 Center Avenue, St. Louis County locator number 24V510034. Proposed use, a total of 4 single-family dwellings on individual lots of record with required street improvements, Ward 8.
Director Vunich, I believe you have a presentation.
Yes, sir, Mr. Chair, and thank you. Mr. Chair and members of the Planning and Zoning Commission, the department has prepared for your consideration tonight its information report and recommendation regarding this particular request. As the commission members may be aware, this particular item was presented to the commission on February 7th, 2022, and at that time, with concerns regarding potable public water, the matter was postponed. The direction to the Department of Planning was to obtain a certification from Missouri American Water Company regarding their ability or non-ability to serve this site. Derek Linham, the engineering manager for that particular company, has provided a letter that is an attachment to this particular report. Regarding the public potable water issue, the department will let the letter stand on its own merits. The department does note that this particular site is located in the town center area, designated under the town center regulating plan as neighborhood edge district, which accommodates detached single-family dwellings on individual lots on a range of sizes and densities. And from the review by the department, it is recommending that the rezoning be granted similar to Old Town Park Estates at Bordeaux, Plat 2, and other properties in nearby areas of town center, i.e. Lindy Lane. Therefore, tonight there is a favorable recommendation for the consideration by the Planning and Zoning Commission. After a motion and second to discuss or to act upon, the Department of Planning will be available to respond to any questions. Thank you.
Thank you. Is there a motion to discuss? Commissioner Broyles,
I make a motion to discuss this issue.
please. Do we need a second?
I could second that.
Thank you.
So,
Commissioner, Mayor Mahone.
well, I was just going to say that somehow historically that got in the annals of the Planning and Zoning Commission. We actually don't need a motion to discuss, but if we are going to discuss, technically we need a motion on the table first. And I say that with all due respect to all of us that have sort of been doing that through the years, but maybe tonight it might be a time to put us back on track here. So one way or the other, we get to the same point, but just technically the better course might be to have a motion. We have the department's recommendation to move forward with this. And then if we get a motion one way or the other on that, then maybe discuss. I think City Attorney Young, is that the better approach rather than motions to discuss?
Mayor, that is the correct approach under Robert's Rules of Order.
Okay, thank you.
Thank you. Commissioner Broyles.
Yes, I have a comment. When we vote on this, is it just to change the what it states here? Are we looking at the actual picture of what this community is going to look like and the surrounding communities? Mr. Vunich?
Ms. Broyles, the petitioner has provided a very defined preliminary development plan that represents the 4 lots with dwellings located upon them. The proposal also gives a general idea of the grading associated with each of them, which is critical relative to stormwater management. So I believe what's in the packet is a good snapshot of how the property would be utilized.
So in other words, we're not voting for the number of houses. Is that what
Yes.
you're talking about?
Yes.
We are voting for the number of houses. And
Yes, ma'am, because again, you're asked to vote for a change in zoning from the NU non-urban resident district, which would only allow 1 dwelling on the existing 1.4 acre lot to 4 on the 1.4 acre lot, obviously subdivided to accommodate the 4 properties.
okay. Thank you.
Commissioner Ward.
Okay, so now is this the properties that the, 3 people were interested?
Ms. Ward, it is not.
It
This
is not,
particular-
okay, all right, fine, thank you.
Thank you, ma'am.
Councilmember Bros.
Yeah, I guess on these proposed 4 lots, I guess the homes to the north, which are relatively new, I guess are on, roughly 15,000 square foot lots. And what's being proposed here would basically be 4 homes on roughly 14,000 square foot lots. Is that correct, Joe?
Yes, Mr. Bros, I believe in this particular case, the subject property will have lots in excess of 14,000 square feet. Those in Old Town Park, which is what is referenced to the north, they range from about 13,900 square feet to over 15,000 square feet.
And then as I look at the site plan, they're all going to have the side entry garages.
That's correct. Wayland Custom Homes, the primary developer in this particular area, has, for the most part, done side entry garages in association with the properties. There is one exception. That's the property that's part of Old Town Park. It's right at the intersection of Center Avenue and Manchester Road, and that one is a rear entry garage.
Yeah. So, I mean, substantially the same as what would be their adjacent neighbors to the north. So the main issue I guess we raised before was the water. I know, we all know there's been a lot of drainage issues there as well. I'm assuming that's going to be part of the development and making sure it's done right. So, okay, I just wanted to make sure because these two are being presented at the same time, and I think sometimes they're getting maybe taken in the wrong order. All right, thank you.
You're welcome, sir.
Any other? Mayor Boland?
I was just going to ask if anyone wanted to make a motion on this.
Thank you. Is there a motion? Commissioner Clayton? You're on mute, sir.
I'm sorry, I move that we put it to a vote.
Is there a second?
So by put it to a vote, I assume he means to support the department's recommendation. Is that correct?
Yes, that's correct. Thank you.
I'll second.
Thank you, Commissioner Helfrey. So there's a motion on the floor to approve the department's recommendations. Is that correct?
Yes.
Is there any discussion necessary? Or do we go straight to a roll call vote? Will it help?
Mr. Chair, if there are no further comments or questions, you can call the vote.
Then let's have a roll call vote.
Thank you, Mr. Chair. Commissioner Doppler.
Yes.
Thank you. Commissioner Helfrey.
Yes.
Commissioner Ward.
Yes.
Commissioner Broyles. Commissioner Broyles.
Yes.
Thank you. Commissioner Clayton.
Yes.
Chair Combe.
Yes.
Councilmember Brost.
Yes.
Mayor Boland.
Yes.
Thank you. Motion passes.
I believe Mr. Newberry, next item is PZ 28-21. Is that correct?
Yes, sir, Mr. Chair. Mayor Boland has his hand up. I don't know if I.
Oh, I'm sorry, I didn't notice it. Mayor Boland, I'm sorry. Please.
Oh, no, that's okay, Travis. I just had that up because I'm going to make a motion once you get done. So
Thank you, sir. Just wanted to make sure.
Appreciate that.
PZ 28-21, Ashley Grove, Cypress Real Estate LLC, care of Daniel Stegman, 16100 Swingley Ridge Road, Suite 210, Chesterfield, Missouri 63017. A request for a change in zoning from the NU non-urban residence district to the R3 10,000 square foot residence district with a planned residential development overlay district PRD for a 5-acre parcel of ground that is designated the neighborhood edge district of the town center regulating plan and located on the west side of Center Avenue, south of its intersection with Manchester Road. Street address 2623 Center Avenue, St. Louis County, locator number 24V420032. Proposed use, a total of 12 new single-family dwellings, along with the retention of an existing residence, thereby totaling 13 units, all being on individual lots of record with street improvements, common ground, and required public space areas. Ward 8.
Mayor Boland, you wish to make a comment before the presentation?
No, after the presentation, Mr. Chairman.
Okay. Director Vunich? You're up.
Thank you again, Mr. Chair. Mr. Chair and members of the Planning and Zoning Commission, the department has prepared for your consideration its information report with recommendation regarding this particular zoning matter. I would first note that the location of this particular request is within the boundaries of Town Center. And being part of Town Center, it does have different allowances and regulations relating to lot size and density. Certainly, the department is cognizant of compatibility and consistency between adjoining properties. And in this particular instance, the developer has submitted a revised plan that was identified in the addendum to the information report. And the changes that were incorporated into that revised plan are part of a numbered list that is within the addendum itself. I think it is important to note that regarding the questions that were raised regarding public potable water, the department does not have the information relating to how the service will be maintained relative to whether it is an increase in volume or pressure or main size, etc. That information certainly can be developed by the department from Missouri American Water Company before the Planning and Zoning Commission will take a final action on this particular request. The department would note that overall, a total of 12 lots is being recommended by the Department of Planning. That 12 lot is inclusive of the existing residence that is to be retained on an existing lot. With the reduction in one lot, all of the proposed lots, excepting the one where the existing residence is to be retained, are now over 12,000 square feet in size and have a lot width of 97 feet. That lot width will accommodate a side entry garage, although there has been no commitment on the part of the developer that all of the 11 lots, new lots, will have side entry garages. Regarding architecture, the standard in Town Center is hardy board or fiber cement siding with backer board. There is a requirement for carriage doors on the garages. There is a requirement for 30-year architectural shingles on all the dwellings. There is a requirement that all vents, stacks, and penetrations from the roof through the roof would be painted to match the color of the shingles. And so for the most part, the same architectural requirements applied in Old Town Park and Wesley Park, the new project that we just discussed, and in Stone Mill subdivision will be applied here. Again, being part of Town Center, the department is cognizant of the requirements relative to density and lot size, and certainly believes that the transition now that is being proposed is appropriate. Therefore, tonight you have a favorable recommendation for consideration. And after a motion, the department will be available to answer any questions regarding that information. Thank you.
Thank you. Mayor Boland.
Thank you, Mr. Chairman, and thanks for the report. So I believe I was the maker of the motion to postpone this at the last meeting. And, these proposals, we want to make everyone happy, but we often cannot. And I am impressed by the degree of compromise that the developer has done in this since our last meeting. And I'm also comforted as to what Joe just said relative to no vinyl and it being hardy board. And I would also mention that I believe the developer has indicated that the home builder in this case is one of very reputable character in terms of the type of homes done. And I think it would be a great addition to our town center area. And so, again, I appreciate the compromises that have been made by the developer based on the request from the commission. And with that, I'm going to make a motion that the department's recommendation be approved to proceed forward.
Commissioner Helfrey.
Before I second that, I have a question for Mr. Vunich. Mr. Vunich, you just said that the houses were allowed to have side or front entry, correct? Garages.
That's correct. sorry.
The houses across the street, across, I think that's Center Avenue, they're gonna have side entry. And the houses on the cul-de-sac behind, I'm looking for the street name.
Falzone Mill Court.
Sorry. So do they also have side entry garages?
Yes, all of the homes that have been constructed in Stone Mill subdivision have side entry garages.
So can we request that these all have side entry garages as well?
Certainly, as the commission, you can make a motion, as has already been made, to approve the recommendation for the rezoning and application of the overlay district. And as a condition of that, require side entry garages on the 11 new lots. So it would be an amendment to the existing motion.
So I could say I'd like to approve the motion with the request that they have side entry garages in order to better match the surrounding houses. Correct?
I believe that's correct, but I would defer to the city attorney or mayor who know Robert's rules of order much better than I. Thank you.
Mayor?
Well, putting Robert's rules aside, I have a question. Is that something that has been proposed by the developer and they're willing to do?
No, sir. In my conversations with Mr. Stegman, the petitioner, there is a builder identified. The builder was not ready to commit to all side entry garages, but will make them available to certain buyers if they should choose. But the current report from the department allows for either front or side entry, but does not place a number or a requirement relative to them.
Well, does anybody else have any thoughts on this?
If I may interject, Mr. Chair, I believe we've got a motion and a second to approve the report. Is that accurate?
No,
we don't have a
There's no second?
No,
Okay.
I'm not making a second. I would like to discuss this a little bit. I don't know.
Well, and the reason I ask is if there's a second to the motion, the next step would be Commissioner Helfrey, for you to make a motion to amend that motion to include the condition. And if that's seconded, then it would be appropriate for debate.
Well, what if I'm not sure that I want to do that yet? I'm sorry. Go ahead, Mayor.
I'm sorry, I got disconnected. I was just going to say that given what Joe said, if I understood it correctly, I think your commissioner, you being Commissioner Helfrey, your comment it has been accommodated by the petitioner. And I guess before I proceed, is that correct, Joe? Did I hear that correctly? That they were going to make that option available to home buyers, the side entry?
Yes, all 11 new lots will accommodate a side entry garage now at a 97-foot minimum width. And so therefore the option is available to all 11 lots.
Okay, so with that, if there's no objection from any member of the commission, since I already made the motion and it's the property of the full commission at that point, I would agree that that could be part of the main motion. And so that would take care of Commissioner Helfrey's second.
Okay, then I second it.
Very good. So we got a motion on the floor to accept the apartment's recommendation with the condition that all garages be side entry. Any further discussion? I guess at this time would be appropriate for a roll call vote.
I think I see Commissioner Brost's hand raised.
Oh, I'm sorry.
Yeah, I guess, Joe, for clarification, like this is like I guess basically a PRD, is that correct?
That's correct, sir.
Okay, so void of a PRD, what would be the lot size?
Since it is in town center under the neighborhood edge district, it could range anywhere from around 5,000 to 6,000 square feet on up to 20,000 square feet. It just would depend on the type of unit proposed.
Okay, so why is it being proposed as a PRD? It doesn't sound like it would be required. I mean, a PRD normally out with us 3-acre people, you know, they're talked about to keep the density at 3 acres. Why is the PRD being proposed here?
It's actually in the opinion of the department, Mr. Bros, to ensure the density does not get too high and is compatible with the abutting area, which includes Stone Mill subdivision, Old Town Park, and I assume soon Wesley Park as well. So I see it as a governor on growth and allows us to ensure that the architectural requirements are not just at the discretion of the developer, but required, such as the hardy board or fiber, cement siding, et cetera. Thank you.
So is this something that the developer, was this a suggestion of the city to be a PRD?
Mr. Brost, it was submitted as a rezoning with a PRD application included with it. So no, the department did not recommend a PRD, but typically residential developments in town center have all had overlay districts associated with them.
Thank you.
Mayor Boland, and then Commissioner Broyles.
Thank you, Mr. Chairman. And I'm really glad that Commissioner Brost asked that question, because while we can never predict the future, one of the things that is in my mind in making the motion that I did was not only in recognition of the developer compromising since our last meeting, but also the fact that, as Commissioner Brost's question contemplated, the fact is, under the rules, a development could be proposed at this location that is far worse than what we're seeing tonight. Thank you.
Thank you. Commissioner Broyles.
And I would like to compliment the mayor and Ms. Humphrey on seeing that as a side entrance. I would like to see all of those as a side entrance, and I think it would make the surrounding homes, and especially in many of the residents, value that. Not the residents who would purchase these homes, but the other communities around it.
Director Vunich.
And just so the department is clear and there is no confusion as it prepares the letter of recommendation regardless of the vote, the side entry requirement is only for the new homes on the proposed lots, not the existing residents that'll be retained. Thank you.
I'm sorry, you were breaking up.
Ms. Perez, I was just making sure that the side entry requirement for the garage would not be applied to the existing residence that is
Oh, no.
located there. Okay, thank
No,
you.
no.
Any further
So
discussion? Commissioner Ward.
So to clarify, we're saying that the new homes that are going to be built, they have an option to request, the buyer can request a side entry. We're not mandating a side entry.
I don't believe that's correct. I believe we're saying that they are to be all side entry. Is that correct,
Is
Director?
that correct?
Mr. Chair, to Ms. Ward, I believe it is now a requirement based upon the motion that is amended by the mayor and seconded by Ms. Humphrey that all of the new dwellings have side entry garages.
So they will all have it. I thought you were saying if they want, if they wish to, if they wanted to have that option.
As the report was first drafted and presented tonight, it was an option between front and side. I believe the motion and second now requires side entry garages.
Okay.
Mayor Boland.
My apology, just a question. Director Vinich, relative to the side entry garage issue, given that I'm assuming that you're obviously more familiar with the aesthetics and of the proposed development and its relationship to those around it, is it your position that, well, let me ask it this way. Do you think it would be better to have flexibility from an aesthetic, homogeneous conformity standpoint as to which residents, you know, giving the residents the buyers and so forth the ability to select that? Or do you think it would be better that each one of them have a side entry garage? And there's no right or wrong. I just want to make sure we get this right from the city's perspective.
Mr. Mayor, thank you for the question. And as you know, in new urbanism, it was intended always to minimize the impact of the garage on the streetscape. So by having side entry garages, that is achieved. To offset potential situations where front entry garages are the only option, we've required the garages to be de-emphasized. And so in this particular case, I still believe with the lot widths and now sizes, that the side entry garage, at least on the south side of the proposed street abutting Stone Mill subdivision, are essential. I think there could be some flexibility on the north side of the proposed street, but certainly the lots are identical, and so it can, I believe, can be accommodated.
So, I mean, I guess given that, my preference would be that we give the discretion to the department on a case by case with this, rather than a one size fits all. But if I'm going to go with the commission, if the commission, wants side entry for, all of it, I think given the compromising that we've seen here, well, let's just go with it. But I think the best decision maker on that would be the department, given the location and so forth, but I leave that to the commission. So.
Commissioner Helfrey.
Sorry, this has to do with the water issue. Mr. Vunich, I guess this would be directed to you. We're talking about right across the street. We're talking about these potable water issues for all of these homes in this area. And my assumption, correct or incorrect, is that these homes will also become part of this issue. And so my question is there, when you talked at the previous item, when you talked about the city would work, can talk about the water issue. And so my question is, how will the city handle these homes being built, adding to the potential water issues in that area? Does that make sense?
Yes, ma'am. And Ms. Helfrey, I believe I understand your question. And so when the department contacted Missouri American Water Company, it made sure it understood that it was just not the 4 lots of Wesley Park, but also the proposed 12 lots of Ashley Grove. So the overall request was, will these 16 lots impact the current situation in the area of Center Avenue and the environs? And Mr. Linham responded saying that these 16 would not cause a decrease in service, and that it would be in the intent of the water company to ensure that. As I mentioned, I do intend to contact the water company to see if I can answer those questions about how that is achieved and the steps in that process. Thank you.
Mayor Boland.
So I think we've seen the letter that's in the report tonight on at least one of these, that they're all in the same area, where Missouri American Water has essentially warranted to the city that there will not be a problem, even to the point of having to change the fire hydrants and so forth to get that done. And I appreciate them doing that. But before the vote, given the side entry garage, we could just go back to that. Would it be okay, Mr. Chairman, if we just kind of do a show of hands on the part of the commission as to whether, is the commission wanting, as part of the motion that's on the floor, mandated side entry garages for each resident, or a presumption that that's what we're going to do unless the department in its discretion, given the location and proximity to this, that, or the other, as someone who's familiar with the development in its intricacies, decides otherwise. That's the question that I have. Could we do a show of hands?
So I'll answer for myself. I would like them to be all side entries so that they are consistent with the surrounding homes. That's what I would like.
And is that through the chair, is that the opinion of the commission as a whole, by a show of hands, if I could just kind of see that?
All right, we show of hands if we agree that all the homes should have side entry garages. Please raise your hand.
Okay, I think that's it right there. Okay, so the motion then will be side entry garages. I just want to make, just so we don't ever have a dispute over it, just want to make sure that we get it right. So the motion, with the consent of the second Commissioner Helfrey and the full commission, is that the department's recommendation be approved with that proviso that all the residents have side entry garages.
All the new residents.
All the
yes.
new residents. Thank you, Mr. Chairman. All the new residents, not the existing. Yep.
Any further discussion?
Do we need to take a vote?
Well, that's what
Yes.
I was asking. If
Was
there's
that
no
it?
more discussion, it's time for a vote. Okay, let's do a roll call vote.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Helfrey,
Yes.
Chair Cohn,
Yes.
Councilmember Brost,
Yes.
Mayor Boland.
Yes.
Thank you.
Thank you. I believe, what's next? PZ 1121, Mr. Newberry, I believe that's you.
Thank you, Mr. Chair. Mr. Chair, members of the commission, if there's no objection, the department will just read the next 5 items by title. PZ 11-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. PZ 12-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. PZ 16-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. PZ 18-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. And PZ 19-21, City of Wildwood Planning and Zoning Commission, care of Department of Planning, City Hall 16860, Main Street, Wildwood, Missouri 63040. Thank you, Mr. Chair.
We lost our chair.
Nature called. Mayor Boland.
Thank you, Mr. Chairman. And so we obviously had a lot of testimony on this. And I understand from the last commission meeting, we had similar testimony, and I was unfortunately absent out of the country for that meeting. And I really want to thank all of the people who both at that meeting and tonight have spoken on this very important issue for our city. We have never before put in place a special circumstances overlay district. And I also want to thank the department for doing all the research that it did relative to which properties to include, which properties to not include, and so forth, and also giving us the reasons for that. Listening to the comments that we've received and reading what the department has presented, I come down to this situation as essentially someone who's going to, I think, would recommend bifurcating the properties, we have 5 tonight, into 2 categories. The first category is those that we know we have known evidence of environmental contamination previously. And I'm not going to get into whether it's there or not now, other than to say that I don't think that is perfectly resolved at this point here in a moment. And those properties that we have no evidence for, there are 3 of them that we suspicion, based on being downstream, adjacent, or whatever, that may be needing of additional overlay district protection. But we don't have, in my mind, solid evidence to say that as of this moment in time, that is in fact the case. Now, if that comes about in the future, then my opinion would change. But relative to 2 of them, properties 162 and 210, we do have at least prior knowledge that there has been, or evidence that in previous previous to tonight that there has been environmental contamination, and there's all the debate about whether the EPA did or did not remedy that or so forth. So I'm going to go into that at the moment with respect to those two, because I was in fact very much involved in the white paper that you've heard, that you've been presented with by the department, and you had comment from people this evening and presumably at the prior meeting relative to that. The fact is that the white paper does not contain inaccuracies as of the time it was written. More importantly, the fact is that much has been made of what the EPA did relative to clearance of these properties, but in fact, and this is one of the reasons the white paper makes the point that further testing should be done, is that, and I can provide you and any of you and any of the speakers this evening with evidence of this from the EPA's own report. What the EPA did on that site was to dig a large hole and to place testing modules around the perimeter of that hole. And some of those tests as to lead, you heard discussion tonight about dioxin. Well, let's put that aside. Let's talk about lead. Lead comes from paint, and that's what was believed dumped there. And relative to lead, the EPA took those tests that they derived from the perimeter of that very large hole, and they rendered a composite decision, because some of those tests indicated that lead was not safe, from the EPA's own test, was not safe for humans to be around. Others on the other side of the hole indicated that it did, so that they were. So what they did was they put them all together and said, guess what? It is okay. We can all have a different opinion as to whether that is an appropriate measure. I do not believe that is an appropriate measure. So the white paper relative to properties 162 and 210, but not the other three, it didn't apply to the other three, in my opinion, remains very much valid as to its recommendation to conclusively determine whether that contamination continues to exist. And there may be studies that were referenced tonight by some of the speakers that show that, and I'm going to incorporate that as part of a motion in a moment. But right now, as far as I know, I don't think I would want someone building a house in the middle of one of those tests on the edge of that hole that had lead that was far beyond what was safe for a human being. So with all that in mind, I'm going to make a motion. And my motion is that the three properties, i.e. those other than 162 and 210, are not within the scope because we have no evidence to support that at this point. And if we ever do, we can revisit it. Relative to the two properties that have known prior contamination, properties 162 and 210, that they be subject to the SCODE until such time as the city is provided with information that in the city's determination objectively and conclusively shows that the testing recommended by the white paper evidences that the concerns relative to the composite testing and any other contamination has been removed. And at that point in time, if that ever happens, those two properties can be removed from the SCODE. That is my motion.
I got a question. We're seeing some chats about no evidence on 162.
So public comment has closed, Mr. Chairman. We're now into a motion on the floor and whether it gets a second. And then discussion and a vote on the motion.
Oh, thank you, sir.
You're welcome.
Is there a second to Mayor Boland's motion? Councilman Brooks.
Yeah, I guess I have a question. I mean, with the mayor's, I guess, process toward his motion, I like the approach. I guess what I was thinking as you were talking, Jim, was that the three where we do not have evidence going in that direction, I think is good. Is there any benefit or detriment or anything to any of the parties that if we were to make a decision on three and potentially instead of having two go into the SCODE, have yet another postponement on 2 to further analyze. And that is a thought. This is something that I know we all take it very seriously. So I'm cautious. If you want to respond to that, Jim.
Mayor Boland.
Mr. Chairman, thank you to the chair. Commissioner Bros, thank you for that question. It is for that reason that I included a proviso in the motion that if at any point in time, evidence is presented to the city that demonstrates the request of the white paper to show that the EPA testing that was done specifically as to lead and that was way over the degree safe for human beings is removed, that these 2 properties, 162 and 210, would be removed without further action of the city. In other words, once that's presented to the director of planning in his or her discretion at the time, whenever that may occur, that decision would not need to come back to the Planning and Zoning Commission. It would not need to come back to the council. They would be removed at that point.
Thank you. Commissioner Helfrey.
Thank you. So these properties have been discussed for years now. And so, Mr. Vunich, could I ask you to weigh in on this, what the mayor is talking about? The 3 properties have never had anything on them, no contaminants that we know of on those properties. Is that correct?
Ms. Helfrey, the department viewed it a little differently than what's been described by the mayor. There is consistency between the mayor's motion and the department's recommendation regarding 157 Strecker Road. And that particular property, the department is not recommending the application of the overlay district, given its limited development potential. On the south side of Strecker Road, which contains the 4 other properties, the department deferred a great deal to the white paper. And Mayor Boland was integral in the development of the white paper and was in discussions with representatives both from the federal and state governments. So in that particular case, I would defer to his knowledge on the white paper and just note that we do have a great deal of information available here at the city, that which it's developed through its resources, and that's which has been provided to this department by outside sources, such as some of the property owners. And certainly the department would be glad to provide that to the Planning and Zoning Commission. Thank you.
Mayor Boland.
So I think the question from Commissioner Helfrey was whether, as to the other 3 properties, i.e. the 3 other than properties 162 and 210, whether there was any known evidence of environmental contamination. And my understanding is the answer to that at the moment is no. Is that correct?
And certainly, again, I will defer to your knowledge of the white paper and the consultations you had with the firm that prepared it. The 2 properties on Idle Rock Lane, those are directly downstream from the area where Mr. Callahan stored the contaminants. And so from that perspective, the department felt that there was a pathway for that contamination to move from 210 Strecker Road onto the properties on Idle Rock Farm Road. And that again was the creek. But certainly, again, I would defer to the mayor and his knowledge of the white paper and how it was developed. Certainly, it was a key element in the department's recommendation relative to the 4 properties on the south side of Strecker Road.
So the white paper only dealt with what is now known as the Callahan site. It did not deal with anything else. So again, my understanding, and I'm not hearing anything to the contrary, is that other than what is commonly known as the Callahan site, which was the subject of the white paper, to my knowledge, there is no known evidence of contamination on any of the other 3, and therefore the basis of my motion.
Mr. Mayor, I concur. It was just that the white paper did describe that downstream groundwater and surface water monitoring was inadequate adequate. And so that is the reason that the department included the two properties on Idle Rock Farm Road. But
Gotcha.
I
Fair
concur.
enough.
I
Yep, fair
concur
enough.
with your assessment that there is nothing that's indicative of Mr. Callahan storing or dumping any drums or any type of contaminants on those sites.
Makes sense. Thank you, Joe. Appreciate it.
Commissioner Helfrey.
Okay, so Mayor and Joe, then here's my question. If my understanding is the purpose of these overlay districts is to protect the current and future property owners. And what I heard you just say was that the monitoring of the groundwater is inadequate at this time. And so if we exclude those two properties on Idle Rock, then it seems to me that those two would need to be included because they are not, you just said they're not being adequately monitored. And if there is anything disturbed or leaches from the Callahan site, those two properties would be directly affected. So I guess I'm missing something.
Mayor, can you help with clarification?
Sure. Thank you, Mr. Chairman, and thank you for the question, Commissioner Helfrey. I think that it would be ideal if that testing back years ago had been done to the satisfaction of those of us involved in developing the white paper. Right or wrong, it wasn't. And when we as a governmental entity are getting ready to do something to someone's property that could potentially be negative, I would prefer to have strong evidence, or at least some evidence, to support what we're doing. And the fact that that testing wasn't done does not give us evidence to show that there is an environmental contamination problem on them. And therefore, I'm reluctant to vote in favor of something that could affect their property values. If the evidence is provided later, that could be a different story, but we don't have that now. So my motion is that they are excluded. The other two are included, 162 and 210, until such time as they provide the city reliable evidence that alters the conclusions contained in the white paper.
Thank you for clarifying that.
You're welcome. I think my motion still needs a second or it fails, Mr. Chairman.
Could you,
Commissioner Broyles.
Travis, could you put that diagram up again of those acres? So are we looking at downstream to 1627 and 1650? Is that what we're looking at?
Yes, ma'am.
Those are the two downstream that's in question. Is that correct?
Yes, ma'am. There's a
Although
continuous.
Although I heard the mayor say 162 and 210. Is that a continuous slope down there?
There was a aerial photograph that was provided as part of the packet that showed what I would call blue lines. Those blue lines were the drainage areas identified for ease of recognition. And so on 210 Strecker, that drainage area begins almost at the location of where Mr. Callahan stored the contaminants, and then heads to the south and southwest through a portion of 1627 Idle Rock Farm Road and a portion of 1650 Idle Rock Farm Road. And again, from the perspective of the department, it is being more cautious than not. And certainly if there is information out there that would be indicating that that caution isn't necessary, I certainly would not want to impose the overlay district in an area where it is not needed.
So we're talking about Idle Rock Farm those two properties?
And Mr. Dewberry is going to enlarge that area so you can kind of see. So with the cursor and the help of Mr. Newberry, the 210 Strecker.
Well, that's much better to see.
Pardon, ma'am?
That's much better to see and understand.
As you can see there, 210 Strecker Road has two fingers of the drainage area. And then it trends to the south and southwest and impacts those two properties in Idle Rock Farms. It's just a tip of one and then the majority of the other. But again, in terms of reviewing the white paper and being cautious in terms of the application of the overlay district, that is why the department supported such. Again, the mayor is correct. There is not direct evidence available indicating that contaminants did transport through those, but there are documentation from when the cleanup was initially done that the fill that was used to cover the drums was set aside and that there was a storm and that fill traveled downstream. So again, there's just a long history associated here, but the application of the overlay district is a serious step. And certainly if there is doubt that it's necessary, I think that doubt is deserving to the property owners.
Mayor Boland.
Thank you, Mr. Chairman. And to follow up what Joe said, Commissioner Broyles, in response to your question, one of the things that we learned, or I learned, I can only speak for myself, when we spent the months we did developing the white paper on this matter, being down, so there is, one of the things is very correct relative to what the speakers indicated tonight is the science, as opposed to conjecture. And in fact, I won't bore you with the whole story, but that's one of the reasons when I became mayor in 2016, I asked for getting science from all sides to develop that white paper to end what I believed at the time was speculation and allegations and conjecture from different areas that may or may not be the case. Let's just find out what the facts are. And so relative to that, one of the things I learned in the process of developing the white paper, simply because a property is downstream does not indicate, it's not indicative that by definition, it's going to be contaminated if something above it on the hill or what have you is contaminated. Because, for example, we live in a very porous karst deposit centric area. And so one of the reasons we recommended on properties 162 and 210 that, AKA the Callahan site, that geophysical surveying be done was to identify two things. Number one, it's an MRI of the earth. Number one, where was the dirt disturbance done? And number two, where are the karst deposits in and around that disturbance? Because it could have leached into the karst deposit and therefore would not have gone, quote unquote, downstream to someone just because they're down the hill. So you look at it from a layman's perspective, and you may think that these other properties for which we have no evidence of there being any environmental contamination on them have it because they're downstream. That's just not the case. It's possible, but it's not the case. And until it is the case, and we know it, and it hasn't been refuted, in my opinion, is the case relative to 162 and 210 properties, I'm just not interested in putting imposition on someone's land.
Thank you.
Thank you.
Commissioner Devlin.
Yeah, I just had a quick question. So I was looking at, where the location of the proposed, new monitoring wells are, and none of them are on that side of the property. They're all towards Clayton Road. And I just wondered if anybody had justification for why they were not monitoring in that direction towards the idle farms.
Ms. Depler, as was discussed by several of the speakers tonight, with the delisting of the property by the Environmental Protection Agency, They believe that there is no longer contaminants associated with any of those sites on the south side of Strucker Road. Therefore, monitoring isn't required.
Just a quick follow-up question, and I know this is from quite a while ago when we first, and I'm saying, maybe a couple years ago when we first started initially discussing this issue, there were people that presented evidence that they thought that there was an indication by some of the governmental agencies that there might still be the potential of contamination at this site. Those particular items have not been shared in the last, year. And I just wondered, if that evidence had been refuted, or is that something that potentially we should follow up on as well?
Mayor Boland.
Point of information, that is exactly why we have Commissioner Depler, the recommendation in the white paper that exactly what you just suggested occur. No more speculation, and it is or it isn't. Get geophysical testing done, find out where there was dirt disturbance, get testing done as to whether there are contaminants, and if it can be done, refute what the EPA did when they did composite testing. Then we'll know it's clear or it isn't.
We have a motion on the floor. Is there a second or any further discussion, Commissioner Broyles?
Yes, when we do vote, could we specifically say the number of the land that we're talking about, the address?
Mayor
The
Boland.
2 and the 3.
I'm sorry.
I've highlighted it on my paper, but I want to make sure.
So I'm guessing, Mayor Boland, we need to restate the motion with addresses for clarification.
Well, I'm happy to do that with some help from the department, of course. If the commission would like that for clarity, my motion was that the 3 properties, my motion that was that properties 162 and 210 be made subject to the SCODE ordinance until such time as the department is presented with reliable evidence that the contamination possibility mentioned in the white paper that we did after exhaustive research no longer exists, and that the 3 other properties, and I didn't use the numbers or addresses of those, but I believe one of them would be the Kruger property, and Joe can or Travis can give us those addresses, would not be subject to the SCODE ordinance because, as I mentioned, there is no evidence of current contamination on those 3. And I think as a government, we should be very reticent to do anything to someone's property until we know factually that contamination in this nature exists. So Travis or Joe, if you want to provide us with the ordinances, with the addresses that would be subject to the ordinance and those 3 that wouldn't, for clarification, that would be great.
Thank you.
Mr. Mayor, those that would be subject to the application of the overlay district would be 162 and 210 Strecker Road. Those properties that would not be subject to the overlay district would be 157 Strecker Road and 1627 and 1650 Idle Rock Farm Road.
Thank you.
Mary, did you have another comment? Your hand's raised, Mary.
Nothing other than that the motion needs a second or it will die.
Okay. Do we have a Commissioner Helfrey?
I'm going to second that motion.
We have a motion on the floor, the first and a second. I think we discussed this enough. Maybe it's time for a roll call vote.
Thank you, Mr. Chair. Commissioner Humphrey.
Yes. Yes.
Thank you, Ms. Humphrey. Commissioner Broyles.
Yes.
Commissioner Ward.
No.
Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Chair Cohn,
Yes.
Councilmember Brost,
Yes.
and Mayor Boland.
Yes.
Motion passes 7-1.
Thank you. Moving right along, Travis, I believe we're at PC 3221, is correct?
Yes, sir. Thank you. PZ 32-21 Grover Heights, Lot 7A, care of Mike Whalen, Whalen Custom Homes, 338 South Kirkwood Road, Kirkwood, Missouri, 63122. A request for a change in zoning from the NU non-urban residence district to the R3 10,000 square foot residence district for a 0.69 acre parcel of ground, 3 lots of record that is designated the neighborhood edge district of the Town Center Regulating Plan and located at the southwest corner of Manchester Road and East Avenue. Street address is 17014 and 17016 Manchester Road, St. Louis County. Locator numbers 24V510452 and 24V510188. Proposed use, 1 single-family dwelling on an individual lot of record, Ward 8.
Thank you, Travis. Ms. Ripito, I believe you're going to make a presentation on this.
Thank you. Mr. Chair and members of the Planning and Zoning Commission, the department is prepared for your consideration tonight an information report with a recommendation for the request that was just read onto the records. The petitioner, Whalen Custom Homes, is seeking a change in zoning to allow for redevelopment of 3 consolidated properties that will total 0.69 acres in order to construct 1 single family dwelling. Included in your packet are renderings of the proposed home as well as a site plan. The plans show that the home will face Manchester Road with access via East Avenue to a side entry garage. The department would note that the city's master plan land use description of the town center area states that the R3 10,000 square foot residence district is acceptable in this designation for the location, and that the density of this individual lot will be much lower than the zoning classification allows. Therefore, it can be favorably considered without the inclusion of PRD, a planned residential development overlay district. The property's designation of neighborhood edge under the town center regulating plan limits future development to single family detached dwellings on individual lots as the primary use. Because the property is located in town center, the neighborhood design standards and architectural guidelines will be applied to ensure the new urbanism character. The department would also note that these lots were platted in the early 1900s and do not meet the 3 acre minimum requirement in the non-urban distance residence district. Given the lots existed legally prior to 1965, they're considered to be legal non-conforming lots, and rezoning the site to R3 10,000 square foot residence district would eliminate the non-conforming status and bring the property into compliance with the setback regulations and such. Additionally, the property owners noted that the eastern edge of the property is often utilized by large trucks leaving the post office when turning onto East Avenue and then onto Manchester Road. The applicant has agreed to a dedication of additional right-of-way area to the city on East Avenue and then constructing the approach to a more rigorous specification to allow said traffic on public right-of-way and avoid future damage to the surrounding grade and property improvements. That being said, in summary, the proposed single-family home is consistent with the requirements to the city's master plan and the neighborhood edge district of the regulating plan of town center, both in terms of respective lot size, setbacks, and other requirements. The integration of the city's other land use codes create the framework to ensure its design and character of the dwelling will be consistent with new urbanism, and the rezoning would eliminate any existing nonconformities. Given the nature of this request, the Department of Planning is recommending favorable consideration of the rezoning from non-urban residence district to the R3 10,000 square foot residence district designation for this 0.69 acre tract of land. And with that, Mr. Chair, the department concludes its presentation. However, the department is here is available to answer any questions that the commission may have. Thank you.
Ms. Richardson. Any discussion? Council member Helfrey, I believe you were the first one.
I was going to make a motion to approve the recommendation.
Do we have a second? Commissioner Broyles? Okay, we have a first and a second. Any additional discussion? Now let's go straight to a roll call vote.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton, Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Helfrey, Commissioner Helfrey, that was a yes. Thank you. Chair Cohn,
Yes.
Councilmember Brost,
Yes.
and Mayor Boland.
Yes.
Thank you.
Ms. Helfrey, so one bark means yes, two barks means no. All right, thank
Something's going on in the other room. I don't know.
Okay.
Sorry.
Next up, we have, I believe, Director Boonage with new business. Is that correct? PZ 7-15.
That is correct, Mr. Chair.
Please
Mr. Chair, pardon me. Mr. Chair, members of the commission, the next item is a response to a communication regarding PZ 7-15, James Edward Hardy, care of Lisa Shearholtz, 826 Babbler Park Drive, Wildwood, Missouri, 63005, which is dated January 3rd, 2022, that requests the renewal of an existing conditional use permit, CUP, in the NU non-urban resident district and FPNU floodplain non-urban resident district, which governs a 14-acre tract of land that is located on the southeast side of Babbler Park Drive, north of Pound Road. Locator number 20X320136, street address 826 Babbler Park Drive. The conditional use permit authorizes the use of the subject tract of land for a horse boarding facility and riding stable, which cannot be utilized for more than 26 horses or ponies, equine, which does not include the property's owner's equine. Accompanying the renewal is a request to amend the conditional use permit, CUP, to change the renewal requirement from timeframe of it from every 3 years, every 7 years. This particular property is located in Ward 3. Thank you.
Thank you, Director Vonig. Senior Planner Travis, I think you're going to make the presentation.
Thank you, Mr. Chair. Mr. Chair, members of the Planning and Zoning Commission, the department has prepared for Commission's consideration a report with recommendation regarding the request that was read into the record. Just a brief background on the property. It is a horse boarding facility that sought a required conditional use permit to bring it into compliance with the city's regulations that began in 2015. The property in the middle of that process was purchased by a new owner, the current owners, who ultimately completed the zoning process by completing the approved site development plan, which concluded in 2019. And the horse boarding facility has been in operation under the new ownership since the summer of 2019. The conditional use permit requires that the permit be reviewed by the Planning and Zoning Commission every 2 years, and that time frame has been reached. At this time, petitioner is requesting a renewal of the conditional use permit. Accompanying that request is that the permit be amended to not require the renewal every 2 years, but rather every 7 years. In the department's report, it supports the petitioner's request for both the renewal as well as the extension of the time frame from 2 years to 7 years for its renewal, given the rationale stated in the department's report. And with that, Mr. Chair and members of the Planning and Zoning Commission, the department's available for any questions. And also note, if there are any questions for the petitioner, their representative, Ms. Shearholtz, is in attendance tonight. Thank you.
Thank you for your presentation. Any discussion? Any motions? Commissioner Helfrey.
I will make the motion to accept the proposal to change the CUP from 2 years to 7 years.
So basically to approve the department's recommendation, correct?
Yes, sir.
All right, Commissioner Clayton, I believe you were next.
I'll second that motion.
Commissioner Deffler, did you have something to add?
I was just gonna,
Understood. Any further discussion? Let's go to a roll call vote.
Commissioner Depler,
yes.
Commissioner Helfrey,
Yes.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Commissioner Clayton,
Yes.
Chair Cohn,
Yes.
Councilmember Brost,
yes,
Mayor Boland.
Yes.
Thank you. Motion passes.
Okay. Senior Planner Travis, would you care to read PZ 10-00?
Thank you, Mr. Chair. A response to an application from Dr. Stuart Monty Robson regarding PZ 10-00, Stuart Monty Robson, which requests certain amendments to the existing conditional use permit and planned residential development overlay district in the NU non-urban residence district and FPNU floodplain non-urban residence district, which would then allow for the inclusion of pet run areas as part of the use of site, along with the addition of training programs and services, while clarifying architectural requirements for all structures and buildings, including fencing, on the approximately 8-acre tract of land that is located at the intersection of Fox Creek Road, State Route 100, locator number 26Y120124, street address 18962, Highway 100. The conditional use permit and planned residential development overlay district currently authorizes the use of the subject tract of land for a veterinary clinic, the boarding and grooming of animals, and other related accessory activities. Ward 6.
Thank you. Mayor Boland, you had your hand raised.
Thank you, Mr. Chairman. So this is actually in my ward. I live very close to it. And first of all, I want to thank Dr. Robson for being part of our Wildwood community. He has been for years. And I am going to make a motion to support the department's recommendation. And just FYI, this all sort of started by virtue of some complaints that happened relative to the placement of a vinyl fence on the back of a vinyl fence, but that's all history because I think this is going to solve everything relative to that. And again, very glad he's part of our city. And so I'm going to motion to support the department's recommendation.
Before the department makes their presentation, is that correct?
I'm sorry, my apology. Joe, do you have anything you want to mention relative to this?
Just very briefly, Mr. Mayor. Mr. Chair and members of the Planning and Zoning Commission, there are 3 items that are subject to changes associated with the existing permit. Those items relate to the expansion of services and offerings that the veterinary clinic would like to provide. The conditions are very well written are well formed to address any concerns relating to these additions. And therefore, as noted, the department is recommending the permit be changed to accommodate the items identified in the reading. Therefore, the department is supportive. And if there are any questions of the department, it would be glad to answer them at this time. Thank you.
Thank you, Director. Mayor Boland, would you like to make your motion?
I would now. Thank you so much, Mr. Chairman. Yep, I would make that motion.
Do we have a second? Councilmember Brost seconds the motion. Any discussion? Let's vote.
Thanks, Mr. Chair. Commissioner Clayton,
Yes.
Commissioner Depler,
Yes.
Commissioner Helfrey,
Yes.
Commissioner Ward,
Yes.
Commissioner Broyles,
Yes.
Chair Cohn,
Yes.
Councilmember Brost,
yes,
and Mayor Boland.
Yes.
Thank
And
you.
by the way, I did not hear, it may have been because of my connection, Commissioner Depler's vote, I don't know if it was a no or yes. It doesn't matter. I just want to make sure we get it right.
Mr. Mayor, I have it recorded as a yes,
Okay, perfect. All
which
right.
is consistent with the thumbs up.
Okay, perfect. Thank you so much.
I believe that was the last item on the agenda. Gosh, it's only 8:30. Have a motion to adjourn. Everybody wants to stay? All right, Councilmember Brost, can I have a second? Commissioner Depler, I think we can do a voice vote on this. All in favor, say aye.
Aye.
Opposed? Or abstentions, whatever that word is. Thank you, everyone. Have
Good
a
night.
Thank you all.
Good night.
Good night.
All right.
Night.
Good night.
Thank you.